Hello everybody. I'm just testing out my screen capture here. I know you are due a video. I'll make sure this is working. There we go. Looks like it's working. Okay, so there were some questions about due process. I've made a quick little PowerPoint in black and white, so it should be easy for everyone to see about due process and what due process is. I'll take you through it. It should help you complete the assignment on due process and answer the questions at the bottom about Mr. Hall. So, due process is defined by the Fourth, Fifth, and Sixth Amendments, as well as just a couple of relevant Supreme Court decisions I'll mention. There are many more if you want to look into those. I'm also going to talk just briefly about the 14th and 8th Amendments. Okay? So let's get into this. The Fourth Amendment, this is it in its entirety: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation, in particular describing the place to be searched and the person or things to be seized. That's a lot of words, so let me just break that down for us real quick. So it guards against an unreasonable search and seizure. In other words, the police have to have a reason to search a person or a place. Um, there are many cases that define what's reasonable. If the police stop you and they see something in plain sight on the seat of your car, or when you open your door to your home, they can enter and take that gun or those drugs. But there are many things that determine what is a reasonable search. And my advice is always don't argue with an officer. That's for the courts to decide what's reasonable and unreasonable. Another time you're subject to a search is when you're arrested. They have the right to pat you down. Um, when you board an airplane, um, that's considered a reasonable search, and you have to do those things. Normally, police will have a warrant. The warrant will be very specific. It will say where they want to search, what they're looking for, and why. So, the second thing you should know about is a court case, a very important Supreme Court case called Mapp versus Ohio, and it gives us the exclusionary rule. And the exclusionary rule says that any evidence that's obtained illegally or through a search that wasn't reasonable is going to be excluded at trial. Now, this does several things. It makes the police do their job correctly. If there's even a question as to whether or not they need a warrant, they will probably get a warrant because they don't want that evidence excluded at trial. So it's a very important rule. And I should mention, some people will say, oh, it's a loophole. They got away with it because the evidence was excluded. Well, you know, we've got to play the game by certain rules, and to make sure that those rules are followed, we have things like the exclusionary rule. If evidence isn't obtained legally, it's going to be thrown out at trial. So that's the Fourth Amendment, guarding against unreasonable searches and seizures. It also kind of, if you read that, it gives you a right to privacy. There's inherent in there a right to some sort of privacy, and people point to the Fourth Amendment when talking about privacy rights. Let's move on to the Fifth Amendment. I'm sorry if I'm talking too fast. Pause this and rewind it if you need to. The Fifth Amendment, again, is fairly long. I'm not even going to read this one. Let's just get into it and talk about what the Fifth Amendment guarantees us in terms of due process. You'll see in there the term double jeopardy, no double jeopardy. And they're not talking about the game show. They're saying that you can't be tried twice for the same crime. In other words, if you're found innocent of a crime, the district attorney can't just turn around and say, well, we'll just do it again. We'll just keep trying this person until they're found guilty. Um, can't do that. That would be against your right against double jeopardy. So that's a phrase you should know. The other thing is you don't have to testify yourself. You can see there it says you can't be compelled to, in a criminal case to be a witness against yourself. And you may have heard people say, I plead the Fifth. Well, they're talking about the Fifth Amendment, which says that you have the right to not incriminate yourself. You do not have to take the stand in a criminal trial against yourself. You may choose to, if your attorney thinks that your testimony is so compelling that the judge or jury should hear it. He may suggest that you do testify. You will then be cross-examined by the prosecutor, and so that's always something to think about and discuss with an attorney if, God forbid, you're ever on trial for a criminal offense. And then in the Fifth Amendment, that it says that you cannot be deprived of life, liberty, or property without the due process of law. Okay, so that's where due process is guaranteed. It's right there in the Fifth Amendment. A couple of other things I'm going to say here, and I'll say again toward the end, is the 14th Amendment also mentions that same phrase, that you cannot be deprived of life, liberty, or property without due process of law. It speaks directly to the states. The 14th Amendment came after the Civil War, and it's rewritten there to say, you know, the states cannot deprive people of life, liberty, or property without due process, as well as the federal government, which was originally intended with the Fifth Amendment for the federal government. The other thing I always like to point out to students, you know, we're going to talk about the death penalty toward the end of our course. And notice that in the Fifth Amendment it says cannot be deprived of life, liberty, or property. It seems to suggest that the Founding Fathers may have envisioned a death penalty. If they're saying you can't be deprived of life without due process, then are they saying that you can be deprived of life if you have due process? So some people who are pro-death penalty will sometimes point to the Fifth or 14th Amendment and say, look, even the Founding Fathers envisioned a death penalty. It's kind of an interesting argument. It's there, and it's something to think about. All right, let's move on to the Sixth Amendment. Sixth Amendment, again, fairly long, not easily read. So let's just jump right into it. Sixth Amendment says that you are entitled to a fair, speedy, and public trial. Well, those are interesting words. What's fair? Well, over time, the Supreme Court and laws have set up rules and regulations and statutes for what a fair trial is, right? What's speedy? Some people seem to be on trial forever. There's so many continuances. There's so many delays. Again, practice and the courts have decided what they think is speedy and what's fair. And like everything else in our Constitution, it's constantly being interpreted by the courts, constantly being impacted by legislation. That's one more reason we should all be paying attention. And of course, you're entitled to a public trial. Now, students will often point out that not all trials or hearings and so forth are public, and that's true. Those dealing with minors are often closed. Family courts are often closed to the public. And again, that was decided by subsequent law and Supreme Court decisions. You're also entitled to know who your accuser is, what you're being accused of, and you're going to have the right to confront your accuser. If you rob me and I'm going to press charges, you're going to have the right to know who it is that's pressing those charges. And you have the right to expect me to show up in court to be there to answer any questions the district attorney has of me or that your attorney has of me. If I don't show for court, the case will in all likelihood be dropped. So those rights are guaranteed there in the Sixth Amendment. You'll also see toward the bottom that you have the right to counsel, which is an attorney. And then I cite Gideon v. Wainwright. Uh, for a while, there were some states that were providing public defenders for people who needed to have counsel, couldn't afford their own attorney. There were some states that were not. A man named Gideon was arrested for breaking into a liquor store. There's no question that he did it. But he argued, he lost at trial. He went to prison, and from prison wrote letters to the court saying that I didn't have an attorney and I should have. This case went all the way to the Supreme Court, and he won. The Supreme Court said all Americans have a right to an attorney, and thereupon that ruling spread across the country, and that's why we have public defenders today for folks who can't afford or don't want to hire their own attorney or counsel. Okay, so that's the Sixth Amendment. Just a couple more things here. As I mentioned before, the 14th Amendment contains the Due Process Clause as well. We'll talk more about the 14th Amendment in an upcoming lesson. The 8th Amendment has a little bit to do with due process in that it says that excessive bails, fines, and cruel and unusual punishment shall not be imposed. So you can't be arrested for stealing a bike and be told you have to post $1 billion in bond. That's an excessive bail. You can't be told you have to pay $1 billion because you stole a bike. What's cruel and unusual punishment, of course, is open to interpretation. As is the way we administer the death penalty here currently in the United States cruel and unusual? Some people argue that it is. I think we could all think up really gross ways to kill people that would be cruel and unusual. But know that those things are in the 8th Amendment. And the final thing, and I know this is mentioned, Miranda v. Arizona is another important Supreme Court case. And that was a case where the arrested person committed a terrible, ugly crime, but later argued, I didn't know what my rights were. No one told me. And the Supreme Court agreed and said that every person upon arrest should be read their rights, right? You have the right to an attorney. If you can't afford an attorney, one will be appointed for you, all that stuff. And in fact, the police call that Mirandizing the subject. It comes from that case, Miranda versus Arizona, which says that you have the right to have your rights explained to you. Okay, so that's what all those things mean. Hopefully that helps you through the lesson. You're going to move toward the end of the lesson toward the case on Mr. Hall. And I will just tell you now, Mr. Hall, a made-up case, has had his rights violated in every way possible. And your job is to tell me, well, he wasn't given a speedy trial as guaranteed in the blank amendment, or he wasn't given an attorney as guaranteed in the blank amendment, as well as Gideon v. Wainwright. He wasn't this as guaranteed in stuff like that. So you have to tell me what right was violated and where is that right guaranteed. If you're an attorney making that case, you have to tell the judge. You can't assume the judge knows. It's got to go into the record. So that's your job with Mr. Hall. Best of luck to you. As always, if you have any questions, let me know. Thanks.